Hi, I'm Carrie Rinker, and today I'm going to be giving an overview of New York farm animal welfare law. This is part of an ag law series that I'm doing here at Lawline. For those of you that have missed it in the past, I have webinars that I've done previously on local food law, embryo transfer contracts, farm leases, and livestock law. And today I'm going to go ahead and delve into animal welfare law. For those of you that don't know me, I'm a farm girl. I grew up on a beef cattle operation in central Illinois. I showed cattle through 4-H and FFA, and I was even a livestock judger in college. I received an Associate of Science in Agriculture from Lakeland College. That's my community college where I grew up. And I went on to go get a bachelor's degree in animal science from Texas A&M. I'm a fighting Texas Aggie. I have a master's degree in ruminant nutrition. I think I'm the only attorney in New York City that has a master's degree in that. And I went ahead and I went to law school out here at Pace Law School, where I received certificates of environmental and international law. I'm currently the chairperson of the American Bar Association General Practice Solo and Small Firm Division's Agriculture Law Committee. We do have a listserv for those of you that are listening in on the live webinar or the recording. I welcome you to go ahead and join that committee if you are interested in this practice area. Feel free to reach out to me directly. We recently had a webinar on intellectual property law with agriculture and then also insurance. My food and agriculture practice is actually based here in New York City, believe it or not. I have an office in Midtown Manhattan at 44th and 5th Avenue. And in the last year, I've also opened up a satellite office in my home state of Illinois. I work with agriculture producers, primarily farmers and ranchers and livestock producers, but I also work with small to mid-sized agribusinesses and increasingly food entrepreneurs, so people making jams and jellies and wanting to sell them at farmers market, folks like that. It's been quite a ride, and I do have a diverse client base. So today's discussion on farm animal welfare breaks up into 4 segments. First, I think it's important for us to see the forest. What's the breadth? What's going on from the national perspective before we can then focus on New York? What's happening at the New York level, and a little bit on how New York fits in to what's happening from coast to coast. Then I'm going to touch on Cowboy Crim Pro. My secretary didn't like that abbreviation, but for those of attorneys that are listening in, I think that we all know that criminal procedure reference. And then finally, I'm going to go ahead and conclude with some recommendations for those of you that have livestock producers as clients. What practical advice can you give them? So that's what I'm going to close out today. So let's go ahead and begin on the national perspective, what's happening in the big picture. And this sort of breaks into 5 different state approaches, both in terms of the roles of humane societies in these 5 different state approaches, and also how these states are actually enforcing animal welfare law. By and large, animal welfare law is a state law. On the federal level, there are some statutes, but today we're really going to be focusing on what's happening at the state level, and then the second part of the presentation will be going into what's happening here in New York State. So from the national perspective, things sort of break into 5 different categories. One being ordinary rights. That's going to be the biggest. 24 states, in fact, do that method. Second is going to be the animal rescue approach. The third approach is the limited law enforcement approach. And then fourth, which is where New York is, which is the law enforcement approach with humane societies. And then fifth, and finally, it is the community policing approach, which is only in Indiana. And we'll talk about that here in just a few minutes. Let's go ahead and begin with the ordinary rights approach. And before I forget, there is a substantive outline today that talks about New York farm animal welfare law. It does not go into the national perspective here with these 5 different approaches. It mostly goes into the New York law, the New York nuances with all of that. But I definitely wanted to highlight that. I hope everyone downloaded it from your materials. So with these ordinary rights states, in these states, humane societies operate animal shelters and they educate the community about animal abuse. But the important thing to understand, in these states, humane societies do not have any police power. And as I mentioned before, and we'll go through the laundry list here in just a second, 24 states, so nearly half of our states, actually take this approach. I wanted to note one state, Colorado. Some states are still allowed to have other regulations that deal with humane societies, such as the types of chemicals used in euthanasia, and Colorado is an example of that. So for those of you taking notes, it's a Colorado statutes 1222-304. That's the citation there in Colorado. Here's the list of states that take this approach. I have Illinois highlighted because I'm from Illinois. I'm now bar licensed in Illinois, and Wyoming, which is a place that I lived for about a year and practiced law out there. Texas is also on this list. So there's quite a few states around the country that are on this list that take this ordinary rights approach. So states with this approach may have a separate enforcement regime, and these sort of fall into 3 different categories. For example, they might have a separate governmental agency that deals with the enforcement of livestock animal welfare in their state. For example, in Colorado, they have the Bureau of Animal Protection. Method number 2, they could have an appointment of specific individuals. North Carolina, North Dakota, and Illinois, all 3 take this approach. In North Carolina and North Dakota, they have a process in which agents are appointed regardless of whether or not they are from a humane society. Now, Illinois requires that the Humane Society endorse an appointment, but the agent does not have to be a member of the Humane Society. So, thirdly, some states like Texas have animal cruelty officers that are appointed at the governmental level. So that's just a general overview of some different methods that these ordinary rights states take. So let's get into method number 2, the big approach, which is the animal rescue approach. States with this approach have Humane Society representatives serve a role at the crime scene by seizing allegedly abused animals and providing treatment. Now, when you go and read the statutes in these states, you will find that humane societies do have some limited police powers. They can investigate animal cruelty in some cases, but they're not able to obtain search warrants. In sharp contrast, as we'll talk about here in a few minutes, in New York, for example, humane societies are able to get search warrants, or specifically peace officers. But in the animal rescue approach states, they have more of a limited role. I wanted to note some specific states with this. So in Alabama, for example, any duly authorized officer or employee of a humane society can seize any animal that is sick or disabled due to neglect or abuse. However, these humane society employees still must satisfy certain due process protection, such as written notice to the animal's owner, and they don't have any additional police powers. In Minnesota, they're unique because their code allows the Humane Society agents to investigate animal cruelty, but then the agent must then get a police officer to have assistance to actually then enforce the animal cruelty laws. So it's a little bit more segregated with the roles in those states. And here's the list of states that take that approach. Alabama and Minnesota are on that list. We just talked about those states. Florida, Kansas, and New Hampshire also belong to this group. All right, we're now on the third big approach, which is called the limited law enforcement approach. Our humane societies in these states are allowed to investigate animal cruelty, seize the animals, and conduct searches. But the police power is still somewhat limited. Like, there's typically no firearms, and they cannot arrest without permission from a police officer or a court. So here's an example. In Kentucky gives Humane Society agents all the powers of peace officers except for arrest and to enforce animal cruelty provisions. The Humane Society agent has to request then an actual police officer to do the arrest. So that's an example of this taking place in Kentucky. So here's the list of states that have that. We just talked about Kentucky, Nevada, South Carolina, Tennessee, Vermont, Virginia, and Washington are also on that list. And aren't those pretty little llamas? I like them. All right, so fourth, we're at 4 out of 5 here for the looking at the national perspective, and this is where New York is. This is the law enforcement approach. So in these states, humane societies are granted all police powers. They are effectively like the police with these types of issues. So they can seize animals, they can investigate animal abuse, they can execute search warrants, and they can issue citations, and they can even then go arrest offenders. Usually, depending on the state, they even have the right to carry a firearm. I know for a fact in New Jersey, right next door, they can. So California's regulatory regime is a little bit more complex. They actually designate 2 different levels of Humane Society agents. I just wanted to note that. So here are the states that are on this list. We see New York, we see New Jersey right next door. Hawaii, California, Pennsylvania, and Rhode Island are also on this list of states taking the law enforcement approach with humane societies and farm animal cruelty statutes. All right, 5th, and finally, we have the community policing approach. So this is where a police officer is appointed to serve as the humane officer. So we essentially have somebody who's already a police officer who's now the humane officer who's going to retain, the power to investigate violations with animal cruelty. And the state that's using this approach is Indiana. So I was going to sing for you today about Indiana Beach, but I thought that only Midwestern folks would get that joke. But something like, there's more than corn in Indiana. There's community policing. So that's a terrible joke. We'll move on. Okay, so let's talk about what's happening here in New York. And this is really where agricultural law meets criminal law. And a lot of people ask me, as somebody who has a food and agricultural law practice, here in New York City, I get asked a lot, what in the world is agriculture law? And the way that I tell it to people, that agriculture law is like every single kind of law. It's just geared towards a specific industry, okay? So agriculture law literally crosses over with every other practice area that you can imagine, okay? So it's contracts, it's environmental laws, estate planning, the list goes on and on. This is the area that crosses over with criminal law, which is why we're going to talk a little bit about misdemeanors and felonies, and we're going to get into criminal procedure as well. So I just wanted to note that. So the statutes here in New York are actually under the Agriculture and Markets Law. So starting at Section 350. And when you look at animal law from a national perspective, oftentimes these are included under the agriculture statutes, although they aren't always. But here in New York, we go ahead and we stick them under the New York Agriculture and Market Statutes. So not surprisingly, it's talking about the act or the failure to act, which causes unjustifiable physical pain, suffering, or death to animals. And the statute regulates both companion animals and farm animals. And what's really important about New York law is that there is a distinction between companion animals and farm animals, and I'll explain why here in a few minutes. Okay, so remember I have this outline here. So I'm referencing a lot of different statutes, and I actually, in the outline, have the full text of the statute, so you can go ahead and reference it. So right now, if you're following along in your outline, I am on page 1. All right, so section 353 prescribes overdriving, overloading, unjustifiable maiming, mutilation, or killing of any animal. More importantly, for those of you that are involved in the agriculture industry, what's important about this provision is that it prescribes depriving any animal of 3 things: necessary sustenance, food, or drink. I wanted to point out a couple of things. The statute specifically uses the word necessary. It does not use the word reasonable. It does not use the word unlimited, okay? It uses the word necessary, sustenance, food, and drink, okay? What's sustenance? Well, there was a court case, People versus Mahogany, and the citation for that court case is on page 2 of your outline, okay? And in that court case, the court said that sustenance includes shelter and veterinary care. So in other words, in the state of New York, you cannot deprive an animal of necessary food, water, shelter, and veterinary care. Those 4 things, okay? So there are a couple exceptions under the statute. I'll go ahead and let you read the full text of the statute after the presentation here today. So there have actually been a lot of different court cases that have talked about this provision, and I actually go through a summary of some of these cases, starting on page 2, so 2 to 3. I'm going to talk about a few of them here in the presentation, but please reference the outline afterwards. So a lot of these court cases are old. This one's a 1974 case. People v, and I am going to slaughter the pronunciation, Arcidicano. Okay, so in this situation, the defendant was charged, he was in charge of feeding a gelding. So a gelding is a horse for 3 months, and he was aware of the gelding's weight loss. A gelding is a male horse, and when it was returned to its owner, the gelding was in such a state of malnutrition that it needed to be mercifully destroyed. And I love that the case law actually used the word mercifully destroyed. Okay, so what's important to take home from this case is that these statutes don't just go to the owner. It also goes to, in this particular situation, there was a bailment, right? Somebody was actually taking care of a horse for somebody else. All right, so that's important in this situation as well. So, and that happens all the time in the livestock industry. Like, for example, in the cattle industry, people lease animals to somebody else, maybe for a season, or maybe they'll lease a bull or a stallion for a certain period of time. Or, a few months ago, somebody contacted me about like a security time, right, with a horse, where this person took the horse for a certain amount of time and to see if that horse would work for him or her, and then took it back to the owner. So during this bailment situation, these animal welfare statutes apply. Okay. All right. Another case was Mudge V State. This is a 1944 state. So again, a lot of these cases are old. So police trooper came in and inspected the barn and found that the main barn door was so swollen that it couldn't be closed anymore. And the livestock were found shivering in 1 to 2 feet of manure. They didn't have any bedding, they didn't have any feed, they didn't have any water during this time. And I bring this out because this just highlights the fact that weather really plays a role into things. And going back to the word sustenance, it's talking about necessary food, water, and shelter for the animal during whatever conditions that are taking place. So sometimes when people come to me with these problems, there have been a lot of rain, maybe it's really cold, so that's where your clients need to spend extra attention, and not only the conditions, but also taking notes that they're taking care of their animals during that period of time. Here's another case, People v. Bowie, I think that's how you say it. This is a 2009 case, so it's a lot more recent here. So in this case, the police discovered 15 horses that were on the property. Some of the horses were dead, while others were severely emancipated. And I just wanted to highlight with this case is that, and it was in Fulton County, New York, and upstate, that it's really important that livestock producers and horse breeders really look at the big picture on what's happening on their operation, because little problems can become big problems sometimes very quickly when something like this is happening. People v. O'Rourke. This is a 1975 case where a court held that an owner of a horse and a hansom cab, I like that, a hansom cab, so basically a horse and a carriage, so the person who was working the horse and carriage basically permitted that the horse was limping and continued to have the horse work, all right? And what's important to take home from this case is that in this particular case, the person that was working the horse and carriage told the owner that the horse was, limping, and the owner of the horse didn't call the veterinarian. So that's the take-home message. The court basically said that the owner of the horse was obligated to call the veterinarian upon receiving notice of the horse's lameness. And I also think that this case is good because it goes into the mens rea, okay, which is something that maybe some of us haven't thought about since the bar exam, but the guilty mind. Because remember, this is where agriculture law meets criminal law, right? Mens rea is going to play a part in all of this as well. Okay, so that was misdemeanor animal cruelty, what we just talked about, and that applies to both companion animals and farm animals. And under the statute here in New York, horses are considered a farm animal. They are not considered a companion animal, okay? Wanted to make that very crystal clear. Now, there's a federal animal cruelty statute. It's also called Buster's Law in New York, okay? This applies only to companion animals. The reason why it's called Buster's Law is because Buster was a cat. And the owner of Buster must have gotten pretty mad at his cat one day because he poured a bunch of kerosene over Buster and then thought it would be fun to light a match. And the cat burned to death. So that's when the legislature here in New York enacted Buster's Law, felony animal cruelty. It is to prevent anybody from intentionally killing or causing serious physical injury to companion animals, okay? And this picture here is my cat Felicity, so I just wanted to note that. But this does not apply to farm animals, okay? So I hate to say it, but somebody pours a bunch of kerosene on a cow, okay, and catches it on fire. It is a misdemeanor in New York, not a felony. The felony statute only applies to companion animals, which specifically excludes cows, sheep, pigs, horses, etc. Okay? And there's more information on this particular statute if you want to read the entire statute on page 4. I'm going to talk about one court case here. There are more court cases that are summarized on pages 4 and 5 of your outline. But in this particular court case, the defendant kicked a dog while wearing boots, and must have kicked the dog pretty hard because it actually killed the dog. So he killed the dog by picking up the dog by its neck and then shaking it. He banged the dog's head against the door, and he threw the dog down the basement stairs. So he was really mean to his dog that day. It's really awful to really think about. And the dog there that's pictured is actually my dog, Taylor. So I can't even imagine somebody doing something like that to a dog. So that is an illustration of what this statute is proscribing. There's another case that's here in our outline about a goldfish. So goldfish are also considered companion animals in the state of New York with felony animal cruelty. Just wanted to note that. All right, let's go ahead and move on to the abandonment of animals. And this is noted on page 6 of your outline, but section 355 in the New York Ag and Market statute proscribes an owner or a bailer of an animal from leaving it to die in a public place, or even leaving an animal in a public place for more than 3 hours after he or she receives notice that the animal is left disabled. So it's a misdemeanor here in New York. I just wanted to note that. So there's actually a 28-hour law at the federal level, and New York has a 28-hour law as well here on the state level, and that's not uncommon. I think a lot of states throughout the country also have a 28-hour law at the state level. This basically states that when transporting livestock or horses for more than 28 hours, then the animals must actually have 5 consecutive hours of rest alongside with available food and water. There's some limited exceptions there in the statute, and I encourage you to go ahead and look at the outline for that. But here's an example. Somebody called my office a few years ago. They were here in New York. They purchased a horse actually in New Mexico, okay, and they were transporting the horse up to New York. And this question came up about the 28-hour law. We just needed to make sure that the person who was transporting the animal was aware about the law, and that documented, okay, I stopped at such and such a time, I gave the animals rest, I stopped for 6 hours here, and then I went on my merry way. And so there needs to be compliance when the animals are going across country or being transported for more than 28 hours. All right, page 7 of your outline goes into more detail about the laws in New York dealing with the transportation of farm animals. Specifically, section 359A1 enumerates a lot of requirements that vehicles need if they transport more than 6 horses. That's the threshold, 6 horses. Okay, and there is a lot of words on that page, and I am not going to read all of them, but I am going to reference the fancy-dancy outline that you have. Go to page 7, and you can see all these requirements that apply to trailers that are transporting these horses. And just wanted to note that pursuant to the statute, like the first ticket is about $250 maximum. And then subsequent to that, we're in the misdemeanor area where it's 1 year maximum imprisonment or $1,000 fine, either or. Okay, so makes sense that poisoning of animals is prohibited in the state of New York, but I wanted to note that it does not require that the livestock owner know that the substance is poisonous, and also it could just be a toxic level of the drug. And this is why also, for those of you that are attorneys that are listening in on this webinar, it's really important to encourage our clients to document things when they are giving when they're giving medicated feed or any type of medication to animals, okay? To state that they're doing it under the supervision of a veterinarian and that they are giving the amounts that are on the label, okay? And I've been talking a lot in the last few months on the veterinary feed directive, which now prescribes extra labeling use, but and you can find that presentation on my slide share if you are all interested in that. But I actually encourage my clients to participate in a voluntary program, any kind of quality assurance program that teaches them about administering medication properly. Like, for example, for those of my clients that are in the beef industry, I recommend that they participate in a beef quality assurance training, and this is administered through the National Cattlemen's Beef Association or the state affiliate. So here at the state level, it would probably be the New York Beef Council would be the group that would be administering BQA. And I have actually gone through the program, so I am certified at beef quality assurance. I like to tell people I'm a certified cowgirl. But the different species actually have their own quality assurance programs as well, such as the pork industry has a pork quality assurance program. And that can, I mean, it's not a foolproof shield, but it could help a court see that the livestock producer, if they did administer a toxic level of a drug, that they did try to take steps with education, that they were working under the supervision of a veterinarian, etc. Okay? So let's get into a little bit with the search and seizure of farm animals, which is actually what a lot of the questions come to my office about. There's a lot of confusion and fear about animals being seized from someone's farm. So just wanted to give the highlights here today. So pursuant to Section 373, any police officer or peace officer, which is an officer of a duly incorporated society for the prevention of cruelty to animals, okay, so that's a big mouthful. So basically we're talking about the SPCA, okay? I'm not talking about ASPCA, okay, with all the commercials and everything. That is a national organization. I'm talking about this state organization, the New York Society for the Prevention of Cruelty to Animals, okay? So a duly incorporated officer from SPCA is considered a peace officer for the purposes of livestock animal cruelty statutes here in New York. Okay, so they can actually lawfully take possession of any animal that he or she believes that has not received proper feed, water, shelter, etc. for more than 12 successive hours. All right, so please review that statute for more information, and it's listed on page 5 of your outline. So when clients come to me and they say, hey, Carrie, what if I just don't let the peace officer on my property? Like, what if I just tell them just to go away? Like, what are they gonna do, right? Come sue me right now. So I tell my livestock clients and remind them that the law actually requires them to cooperate. So Section 369 of the New York Ag Markets prescribes the interference or obstruction of a search by a police officer or a peace officer, right? A duly incorporated society for the prevention of animal cruelty, so SPCA, to the animals with a valid warrant. So if they come to the farm with a warrant, and I mean a peace officer or a police officer, they have a valid warrant, the farmer, the livestock producer, the horse breeder, needs to cooperate with that search. They have a warrant. And for all intents and purposes, a peace officer should be treated with the same respect that a police officer should in this situation, because in the state of New York, if you remember, as we were looking at all 5 of those approaches, in the state of New York, we are a law enforcement state. Peace officers are basically clothed with police authority. So if the farmer or the livestock producer, horse breeder, etc., does not cooperate, they're a jerk about it, they don't let them on the property, it's a misdemeanor. Page 10 of the outline gives more information about that. And I just wanted to also note the citation that talks about the duly incorporated societies for the prevention of cruelty to animals. I'm going to try to say that fast 3 times, and that's in CPL 2.10 subsection 7, and that's really what we're talking about here today. So peace officers and police officers, either one, can get warrants to search and seize animals from farms. And that power comes from Section 372 in the New York Ag and Markets Act. And that's whenever somebody believes that there's a reasonable cause to suspect animal cruelty. In New York, they can actually use video cameras when they come on the property and they do a search and a seizure. I recommend to my clients that if there is, if a police officer or a peace officer comes to the farm and that's what they're doing, is they are searching and seizing animals, that they get out their smartphone and they start video cameraing as well. But absolutely, the peace officer, the police officer can use video. Informants can be used, and I wanted to note that warrants must be precise in these situations. So I am not a criminal lawyer, I am an ag lawyer, and but I give a lot of presentations in this area, and I speak to a lot of livestock producers. Most of my questions actually come in the area of criminal procedure, believe it or not. So I am going to spend a little bit of time talking about it. I am going to be breezing by it a little bit for a few reasons. One, I'm not a criminal lawyer, right? This is not my level of expertise, which brings me into point number 2, that I really believe that when defending these types of charges, okay, so if you are an attorney who gets a phone call from a livestock producer, a horse breeder, who said, hey, I was just arrested, I have misdemeanor charges, I have an arraignment coming up, I need defense counsel. In my own experience, I work with a criminal attorney, okay? It's kind of like a tandem team here. We have an ag lawyer and we have a criminal lawyer. And you can test out your own comfort level and how you feel in criminal courts. But for me, I like to work with a local criminal attorney in that county, and I'm sort of there giving advice from an agricultural and animal law perspective. Okay, so the Fourth Amendment is going to prevent unreasonable searches and seizures of animals, okay? So this is a constitutional issue, and there was a fantastic article that was written, the name of it is escaping me. It was written by Beth, who's at the National Agriculture Law Center, and it was talking about how this is a little bit of a constitutional issue here with the search and seizure of animals, and encourage people that are listening in today that are interested to investigate that further. But does the Fourth Amendment apply? And I know I really am going back into bar exam preparation mode here, but yes, the Fourth Amendment applies. There is government conduct. In New York, humane societies are deputized with police powers. They're essentially acting like a police officer, right? So yes, the Fourth Amendment does apply in these cases. And the person who must have a reasonable expectation of privacy, just have a few things I wanted to state here, that aerial photography, there's no standing, right? So if somebody's taking pictures over a farm, there's no Fourth Amendment standing there. It's something that I completely just made up was, is there a valid search warrant? SNAP, S-N-A-P, and S stands for the warrant must be specific. N, it must come from a neutral and detached magistrate. A, it's from an oath or affirmation from a police or a peace officer to a judge. And P, there needs to be probable cause. So that's just something that I tell my clients to just always keep in mind on whether or not the search warrant was valid. But at that moment, they can't really make that argument. They need to cooperate. If a police or a peace officer comes to the farm with a warrant, I can help them make those arguments later with the help of a criminal attorney. All right, so the next question is, was the warrant executed properly? And the reason why I'm going through all of this is just because if you are defending a livestock producer that has these charges, don't forget that you can go through things from a procedural standpoint as well, looking at whether or not the warrant itself was executed properly, was it specific, did they go outside the scope of the warrant, etc. Which brings me to this example. I know of a particular case where a warrant was for dogs. This person was a dog breeder, okay? So for dogs in a backyard, and then what happened was when the police or the peace officer got there, then they started investigating things in the barn, okay? So the warrant should actually say what is being investigated and where, okay? And they shouldn't go outside of the scope of that warrant unless, with limited exceptions, right? Unless, something is in plain view, or unless they believe that there's an emergency that's taking place, if there's exigent circumstances, right? So for the sake of time, I'm going to go ahead and move through this criminal procedure, but I just wanted to note all this too, because I think it's important to keep this in mind when working with an agriculture producer with the procedure here. It can be very scary. They could be arrested, and Miranda rights, all of these things apply that I think that we all learned, or second year of law school here, right to counsel, right to remain silent. Was there an improper search? Did they go outside of the scope of the warrant? The fruit of the poisonous tree, all of these things apply in these cases. Here in New York, they can use videos, I already mentioned that, and electronic surveillance. There's more information on this in your outline with citations. I would encourage you to go ahead and to look at that. A question that comes across my desk quite often is from producers that have biosecurity concerns. Maybe they're a wash-in, wash-out facility. I don't know if any of our listeners here today or on the recording have been to such a facility, but I have. I mean, I've literally have gone in and had to, take a shower and change my shoes or put on new clothes. And so they've got questions about what happens when a police officer or a peace officer comes to their biosecure facility with a warrant, and maybe the warrant doesn't say anything about the biosecure facility. So I wanted to note that there are some federal schemes here that take precedence under the Supremacy Clause, and that being with the Animal Health Protection Act, and also the Food, Drug, and Cosmetic Act. And inspectors should coordinate ahead of time with local law enforcement if biosecurity is an issue. So, I think that there's a potential argument that the farm could then seek an injunction in federal court. So it's an interesting legal issue. I actually don't know of any case where this has actually came up from a practical standpoint, but it could certainly raise some interesting legal issues if it did arise. So animals have now been seized, all right? What takes place now is that under the New York Ag and Markets Law, specifically Section 373, these animals can then be impounded. There will be a hearing that will take place within a 30-day period of time where the owner of the livestock or the horses will then need to post security. All right, so and a failure to pay the security could lead to a court ordering the forfeiture of the animals. And I was just having a conversation with my associate about this today, and the statute does not say how much the impounding organization can charge. It's kind of like a reasonableness argument here, and they're going in front of a judge, and organizations in different localities are going to have different expenses. What type of animal are they taking care of? So there's no standard fee of X number of dollars per day per this species of animal. That's not in the statute. And I've received a lot of complaints from livestock producers that the the amount that is being sought for with security with these animals is a lot of money. So for those of you that are planning on practicing in this area, you need to prepare your clients for the fact that if something like this comes into play, they need to be ready that there's going to be a lot of cash that might be required for them to have security to get their animals back, unfortunately. Okay, so there is a return of security after adjudication. So upon adjudication of charges, a person who posted security is entitled to a return or refund of the security that is remaining. Upon acquittal or dismissal of charges, a person who posted security is entitled to a full refund and return of impounded animals. So when thinking about things from a defense perspective, it's important to also think about expert testimony. And I'll talk about things from a practical standpoint in just a second in terms of relationship building. But some types of experts that are used in farm animal cruelty cases might be veterinarians. That's going to be the most common. Veterinary technicians, maybe dog trainers. If it's a dog case, animal behavioralists, maybe some reputable breeders in the area, reputable horse breeders, etc. So just some things to think about from a defense standpoint is who are your expert or experts going to be? There are a few counties here in New York that actually have animal abuser registries, okay? So if somebody is convicted, if they're found guilty of a misdemeanor or a felony, could be either one, they could be required to be listed in this animal abuser registry for a certain period of time. Like they physically have an obligation to then go to the registry. It's going to be different in each of these counties. Oftentimes it's going to be at the police station, okay? And it's not automatic. So if you are representing somebody who was convicted, make sure they go ahead and follow through with this next step here. With Suffolk County, the length of time is 5 years, and it's listed in page 20 of your outline, so please go ahead and read that for more information. In Rockland County, it's 4 years, and more information on Rockland County is on page 21. In Albany County, it's a decade, 10 years. That's the longest, and that's on page 22 of your outline. In Westchester County, it's for 10 years, and it's on pages 22 and 23 on the outline. And it didn't make the slide, but it's in the outline. New York County also has a registry. It's on page 23 of your outline. Nassau County out in Long Island is on pages 24 and 25. And then finally, Orange County is another county, and it's on page 25. So what does this really mean? How does that affect somebody? I think it's going to affect companion animal people more so than livestock people. And so let me explain. In some counties, not all counties that have this registry, if they're wanting to adopt again, the local shelter in some counties are required to actually check the online animal abuse registry to see if the person has been convicted either with misdemeanor or felony animal cruelty, and that person's not allowed to adopt an animal. It's public, right? It's like public image, but it doesn't prevent the person from, owning a horse again. So there is some limited applicability here with that, but I do want to note that the local registry trend is growing here in New York. A few years ago, I think was when it first started with Suffolk County. I think that was the first county that had a registry. And remember how I said that this is an additional requirement. So there are some penalties that are imposed for failing to register. All right, so we've gone through a lot of information, and for those of you that are practitioners that have livestock producers as clients, I want to have just a few take-home points here that you can give your clients on how to maneuver through all of this. okay? So a question that I get is, what if a non-police officer visits the farm and asks to look around? And I actually have written a lot of articles on this, and they're on my JD Supra page. So if you Google my name, Carrie Rinker, and JD Supra, you'll come across my page. And I think I have about 3 articles that have been written for this over the years that have been published with the New York Farm Bureau, okay? So the first step, I think, is ask for identification, right? So remember, with peace officers in New York, we're talking about essentially the SPCA, right? There was an instance a few years ago where people from another group came to a dairy farm. And I think in this instance, they actually said they were from the New York Farm Bureau. New York Farm Bureau is not a duly incorporated group that's eligible to be a peace officer. And there are a lot of animal groups that are not, don't fall into the category of being a peace officer. So it's really important that livestock producers first ask to see identification. Are they a police officer? Are they from SPCA? Number 2, ask for the warrant, okay? Do they have a warrant? Do they not have a warrant? If they don't have a warrant, that doesn't mean that you shut the door in their face, but you need to know if they have a warrant or not. Let's assume that they have a warrant. Then I encourage my clients to actually read the warrant. Take a minute, read the warrant. Is the warrant for dogs in the backyard, or is it for cattle in the barn? What is the warrant for? Ask if the peace officer or the police officer has a camera or video equipment. If they do, then make sure they have their camera ready. 5th, I advise my clients to take notes during the farm inspection. Specifically, what time of day is it? What is the body condition of the livestock that are there? Maybe they came at a point of the day where you are literally on a regular basis, you have a record showing this, 1 hour away from feeding the animals anyway. Maybe there's no food or water out in front of the horses at that moment, but you were going to go out there in 30 minutes, per your history, to put food and water out there. So take notes during the time. Where did they actually go? What animals did they look at, etc. And also, if there are particular animals that are sick during this time, take note of that. Obviously, I think it's better for every farmer, every horse breeder, to already have a relationship with an attorney ahead of time, okay? And I think as lawyers, that's what we really need to be selling, is that let me be your general counsel for your farm. So when an issue arises, we already have a game plan in place and we know how to react. We as attorneys can help a particular farmer or horse breeder develop a defense strategy, and that could include record keeping. What time do you go out to feed your animals every day? When do you go to the veterinarian, etc. And discuss a plan of attack. Are there special biosecurity concerns with that particular operation? Is it a wash and wash out facility? Have a protocol in place for visitors and also police and peace officers. Some more tangible things that I recommend to my clients are thinking about an employment handbook, which I think is actually pretty rare, or it's more rare with agriculture production operations. Okay, but I think enumerate animal handling policies in this employment handbook, memorialize training those employees on a regular basis of those proper animal handling techniques. And as a company culture, farm culture, participate in this voluntary animal welfare programs, such as, I already mentioned, BQA, beef quality assurance, but there are all sorts of different voluntary animal welfare programs that I think it behooves the farmer and the horse breeders, etc., to participate in these programs. It helps build a written defense ahead of time, ahead of there being a problem. I also recommend to my client that they start building a relationship with industry experts. I've had conversations with livestock producers, and maybe they're having this problem, and I ask, well, when was the last time you went to the veterinarian? And, oh, well, it's been a while, and I don't like that veterinarian. I'm having trouble finding another veterinarian that I like. No, that's not the answer. Build a relationship with these experts ahead of time, so then that way, if there are criminal charges, then that veterinarian can get up there and say, I've been this farmer, this horse breeder's veterinarian for X number of years. I see this person on a regular basis. And then have your client actually document their visits with the veterinarian and taking and implementing those recommendations from the veterinarian. In some situations, not all situations, but livestock producers and horse breeders need to have a relationship with a nutritionist, okay? Document implementation of those nutrition recommendations. And every state in the country has a land grant university, okay? So in New York, the land grant university is Cornell. In Illinois, which is where I'm from, it's the University of Illinois. In New Jersey is Rutgers, okay? And the land grant university operates cooperative extension. I recommend that my clients have a good relationship with a cooperative extension specialist, depending on whatever species that they have. Document going to one of their seminars, any notes that you have. If they come to the farm, any recommendations that Cornell Cooperative Extension Specialist has. Keep records of visits and any noted improvements and compliance with those recommendations. Like, I did this and I noticed a change in the level of health of my cow herd and the body condition score. Keep a record. Maybe even use a smartphone application for all of this. There's an app for everything, right? So really think about building that defense. I had a livestock producer in my office within the last 6 months, and there were photographs that were taken at the time where there was a search and seizure of the animals, and he or she was like, well, this is not how my farm usually looks like. And then I asked, well, what does your farm normally look like? Do you have photographs? Well, no. Well, take photographs. Start building a fence ahead of time. On a regular basis, have a reminder that you're going to take photographs of your farm every Monday, right? Just do it. Keep diaries. Start building a written record. Know who to hire. I spoke last March to the New York State Bar Association Committees on Animal and the Law on a presentation on ag-gag, okay? But a big chunk of that presentation was actually on hiring practices. I think that this is important. Farms need to really think about who they hire and having proper hiring practices in place. The outline from the presentation is on my JD Supra page. I would recommend looking at that. I think people should pay attention to their public image. I do recommend to my clients that they go back to their farm and fix broken windows. And I got this whole thing because I read Malcolm Gladwell's book. I think it's in Tipping Point that he talks about broken windows. Sorry, I'm wondering what book Malcolm Gladwell did that in. But basically, the theory with broken windows is this. And it goes back to Mayor Giuliani fixing crime in New York, where he started enforcing petty crimes and then the murder rate went down. It's the same thing for farms, okay? Fix the little problems to help the big problems. Think about corporate formalities. Make sure, drive around your farm, look at the fence lines. What does an aerial photograph of your property show? How does your social media what does it look like? What does your farm website look like? Pay attention to your public image and those broken windows. We all have them. Every farm, every business has those broken windows, and I encourage my clients to pay attention to those. So for the sake of time, I'm going to go ahead and close with a few final comments. I'm a food and agricultural lawyer. For those of you that are interested in growing and building your own food and agricultural law practice, I do have Skype calls that are on the first Friday of each month at 2 o'clock Eastern Time. It's free. You can pick my brain for an hour, no matter if you're a law student or you've been practicing for a number of years and you're interested in working in this area. Go ahead and email me directly at carrie@rinkerlaw.com. I did write a book. I actually have an entire chapter of the book dedicated to New York farm animal welfare law. So if you like today's presentation, please buy the book, and hopefully that chapter will be a good reference for you. And I'll close with my contact information. I'm very involved in social media. Please tweet me, Facebook me, Instagram me, read my blog, link to me on LinkedIn, and if you want, you can even send me snail mail. So here's my contact information. I look forward to being in touch. I'm doing one more presentation for this particular series next summer on agriculture contracts, so please stay tuned for that. And thank you for your time and attention today.